Good morning all, and welcome to this morning's webinar, Public Law Quarterly Recap. I am Fiona Scolding, KC, and I will be chairing the session today. You will be hearing from my colleagues, Charles Bishop and Miranda Butler. Now, without any further ado, the excitement has mounted and we are about to start Public Law Recap. We have two excellent speakers today, Miranda and Charles. Miranda has a broad public law practice. She's been involved in some very high-profile cases in the Appellate and Supreme Court, particularly in respect of trafficking and refugee and immigration work, although she practices in a wide area relating to health, education, and other matters. Charles is also one of the juniors in Chambers. He again has an extremely high-profile and varied practice, acting in matters as disparate as planning injunctions in respect of immigration centres, sewage and care homes. So a wide range of factors there. I'm very much looking forward to hearing their words of wisdom as to recent practice and procedure in respect of the administrative court. So without further ado, I hand over to Miranda.
Thank you very much, Fiona, for that unduly generous introduction. So I am today going to be talking about anonymity directions and witness evidence in particular. Whilst a number of the points I'm going to be covering will hopefully be familiar to practitioners attending today, there have been in line with the trend towards greater procedural rigour in the administrative court, a number of judgments recently emphasising greater strictness and even higher standards in relation to these two areas. So firstly, anonymity directions. I'm sure everybody here is familiar with the procedural basis for an anonymity direction. CPR 39.24 allows not only allows, but mandates that the court must make an anonymity direction in relation to a person where it considers that non-disclosure is necessary to safeguard the proper administration of justice and in order to protect the interests of a party before it or a third party. One might think that that's a fairly modest threshold, but we shouldn't be encouraged, recent judgments will tell us, by the language of the CPR into thinking that that is an easy standard to meet. Furthermore, of course, when we're looking at anonymity directions, there's likely to be human rights engagement, including often issues relating to privacy and rights to family life under Article 8, and they're balancing against the Article 10 entitlement to freedom of expression. The Human Rights Act, in an often overlooked provision, perhaps suggests that when balancing interests involving freedom of expression, the balance might be tipped slightly in favour of Article 10, because it mandates that the court should have particular regard to that right and its importance. And in cases involving journalistic, literary or artistic material, which often arise in the context of anonymity directions, the court must have regard to the degree to which the material in question is available to the public, or perhaps more significantly, the degree to which the material is in the public interest for it to be published. So that's the procedural backdrop and the human rights backdrop, but what does the common law have to say about principles around disclosure and anonymity? Notwithstanding the human rights framework, the common law principle of open justice remains live and relevant, and perhaps even determinative in these cases. I'm going to come on to discuss a little more what that involves, but in summary terms, it essentially involves the obligation and expectation that in general justice will be done in public, and parties to legal proceedings, including witnesses and third parties, will be named. There are some statutory exceptions to those principles, and certain categories of individuals are in fact entitled to anonymity. This includes victims of alleged sexual offences, victims of trafficking, children in family proceedings, children before the youth courts, and victims of female genital mutilation. You will note that that list of categories doesn't involve refugees or asylum seekers, and indeed there is no automatic entitlement to anonymity in those cases. The Supreme Court confirmed in the case of Kambadze that anonymity, even in international protection claims, has to be justified on a case-by-case basis. In that case, rather unusually, counsel for the Secretary of State invited the Supreme Court to continue the anonymity order that had been made in the courts below, whilst counsel for Mr. Kambadze took an essentially neutral position. And in the absence of a more positive case being advanced, the Supreme Court, as we can see from the title of the proceedings, set aside the anonymity order that had been made. However, it's well established that if an asylum seeker or refugee or other person with an international protection claim fears harm to themselves or to third parties, that is a factor that would militate strongly in favour of making an anonymity direction. Interestingly, the case of G that I've cited on this slide also refers to harm to the integrity of the asylum system. One could, for instance, imagine a scenario in which were asylum and protection claimants not generally given anonymity, that might discourage them from bringing and pursuing legal proceedings, including proceedings related to their asylum claim. And it's those factors that have led the Court of Appeal to issue the practice guidance that you'll see cited at the bottom of the slide, which refers to its long-standing practice of anonymisation in most appeals raising asylum or other international protection claims. The guidance does emphasise that the court nevertheless has to be satisfied that the publication of the names would create avoidable risks for them in their country of origin. However, in practice, what has often been seen in this category of claims is an almost automatic making of anonymity directions. And if that was the trend historically, I am going to suggest that at least as of last month, it looks as though that trend may be coming to a close. And in particular, I'm thinking here of the recent judgment in M&L versus Westminster Magistrates Court. M&L is a successful businessman who was concerned about identification as a third party referred to in forfeiture proceedings concerning Azerbaijani oligarchs who had been accused of money laundering. He explained that he was concerned that if identified, it could be harmful to his reputation and to his business, and did initially obtain an anonymity direction, but this was then set aside. And that decision to set it aside was appealed to the divisional court. And what we received last month was a detailed and closely reasoned judgment from Lord Justice Warby, and also a concurring judgment from Mr. Justice Mostyn, which contains some very helpful guidance applicable across the board, not only in claims for anonymity, but for any claim where a restriction on disclosure is sought. I've attempted to summarise Lord Justice Warby's quite lengthy judgment, but the essential principles he sets out are that the starting point in these claims is one of open justice. In general, justice should be done in the open, should be in public, and the names of parties and third parties should be reportable. The test where anonymity is sought is one of necessity. Frustratingly, there's two slightly differently expressed tests, but I'm not sure they are likely to lead to a great difference in practice. At common law, the test for anonymity is whether a restriction on disclosure is strictly necessary in the interests of justice, whereas in the human rights context, the question is, of course, whether such restriction is necessary in pursuit of a legitimate aim. This claim was decided in the human rights context, and the court emphasised that it's not enough merely to make reference to the interference with private and family life that adverse publicity is likely to pose. Such interference must attain a certain level of seriousness for the court to consider anonymity. And where that threshold is crossed, the court will then engage in the balancing exercise that all of us who have ever had anything to do with qualified rights under the ECHR are familiar with. The court will assess whether that interference is proportionate. As part of that assessment, the court will ask itself whether the claimant has adduced what's referred to as clear and cogent evidence in support of their application. And once again, this is quite a high and demanding standard to meet. It is not sufficient simply to assert that there will be embarrassment, that there will be public opprobrium. To a certain degree, the divisional court envisages embarrassment or exposure as an inevitable part of litigation. In this case, the court found against M&L, but the reason why I'm still referring to him in anonymised terms is that the judgment is currently under appeal. So what do we do in light of this new judgment? I think that the best approach is to beef up the submissions and evidence that have generally been put forward in support of anonymity applications. Firstly, I think detailed written submissions are likely to be necessary. You may be representing someone who's simply entitled to statutory anonymity. I, for instance, represent many victims of trafficking who should automatically be granted anonymity. But in any event, mindful of M&L and some of the other judgments I'm going to mention, I have been making detailed submissions even in those circumstances. If you're not entitled to statutory anonymity, you need to set out the risk of any harm that might be identified. That might be, for instance, in an international protection claim, a risk to life or a risk of inhuman and degrading treatment for your client or their family, or it could be Article 8 factors such as those identified by M&L. The balancing exercise needs to be addressed with rigour, and in particular, the degree and extent of any public interest in disclosure should be addressed. Those submissions must be supported by witness evidence, and my advice is that that should generally come from the individual seeking anonymity. It's not sufficient to refer broadly to the fact that you're within a category who may wish to be anonymised or to make sweeping assertions. Your submissions and your evidence must look at the individual facts of the case and the degree of interference with your client's individual rights that have been raised. There's been one substantive judgment and one order from Mr. Justice Mostyn following on from M&L. And in both cases, he has given detailed and careful reasons when it comes to granting anonymity orders, and has reiterated his view that this is a high threshold to cross. So firstly, in TT and Essex Council, which my colleague Charles is going to come on to address you on, he emphasised that parties to proceedings should be named unless there's a very good reason not to. So essentially, there is a weighty presumption against anonymity, even in cases such as this involving vulnerable young people. He also emphasised, perhaps somewhat unusually, that an anonymity order should, as a starting point, always have an end date. And in that case, he set an end date 2 years in the future. And so when you're making your submissions, you should be thinking what end date you think is appropriate. And you should be aware that if you're seeking an indefinite anonymity order, whilst that is very commonly made in the administrative court and in other courts, it's wise to make sure that you're giving detailed reasons as to why that's necessary. In AH and other, which I have to declare an interest in, I'm counsel on that case, Mr. Justice Mostyn granted anonymity, but with some hesitation. In particular, in that case, he was concerned about the contents of a witness statement from my instructing solicitor that referred to what is well documented in country guidance cases and background evidence, namely that the authorities of the country from which my clients come are liable to identify asylum seekers abroad. However, he characterised that as mere assertion, and it's a useful reminder that in making a statement, a solicitor or a client should be careful to avoid inadmissible opinion evidence, even if it is on a matter that is potentially well established by case law. If you are going to be making such an argument, it would be wise to make sure that you are referring to background evidence or jurisprudence. So in short, it's become more difficult to obtain anonymity. It's certainly not impossible. And I do think some judges are still making these orders really as a matter of course in cases where they've been made previously. However, we need to be more cautious and careful in how we approach these applications. Moving on now to witness statements and expert reports. The case of MQ that was handed down earlier this year contains a number of critical comments about the evidence adduced before the court by the claimant. It was a challenge to the system of accommodating asylum seekers in hotels, which I'm sure everyone here will be very well aware of, which was unsuccessful. But for our purposes, what is significant is the criticism of the witness evidence, which was adduced not in the witness's own language. The court re-emphasised that the CPR requires that witness statements and statements of truth must be in the witness's own language. In this context, witnesses had put in statements in English when they didn't speak English, but which included a reference confirming that the statement had been translated to them and they had understood it. The court said that was not sufficient. So a witness statement in the client's own language should be filed. It should be filed with a translation, and both the witness statement should be signed by the translator, who should also certify that the translation is true and correct. In MQ, admittedly against the backdrop of the Secretary of State not disputing the admissibility of the evidence, the court did reluctantly admit the non-compliant witness statement, but this is a pitfall that hopefully we can avoid in future. I'm conscious that sometimes it can be difficult to comply with these rules in particularly urgent cases, and I have on occasion where it hasn't been possible to comply with this, filed a witness statement that is non-compliant, that is essentially in the terms as an MQ. It confirms that the statement has been read to and understood by my client. And then I file a witness statement from my solicitor explaining why it's been impossible to comply and confirming that we will comply with the rule as soon as possible. And I haven't faced any criticism yet. Similarly, in MQ, there was a brief reminder about the possibility of solicitors signing a statement of truth on their client's behalf. I'm sure you're familiar with this possibility. And it, as a reminder, what Practice Direction 22 permits is for a signature to be placed on a client's witness statement by their solicitor, which will be taken as a statement that the client has authorised the signature, that their legal representative has explained that by signing the statement, it will be taken to represent the client's belief that the contents of the statement are true, and the legal representative has explained the possible consequences of the witness being found not to have an honest belief in the truth of the contents of the statement. Again, this is a context in which, whilst this is a possibility, I am generally quite hesitant about asking legal representatives to sign their client statements where this isn't possible. What I have done previously, again without judicial criticism, is to file an unsigned statement supported by a statement from my solicitor, which is signed and which explains why it hasn't been possible to sign and why a compliant statement will be provided as soon as possible. Finally, one of the biggest issues in the evidence in MQ was that the expert reports filed with the court were not compliant with CPR 35 and its practice direction. Again, I'm sure everyone here is aware of these provisions, that in particular, the requirements that the experts state that they understand and have complied with their duty to the court, the requirement to include a statement of truth, and the requirement to confirm both that the experts are aware of CPR 35 and its practice direction, and also the guidance for the instruction of experts in civil claims. Unfortunately, in MQ, the expert reports were treated as inadmissible and due to the failure to comply with these requirements. And as you can see below, the court said that it was simply fatal to the admissibility of the report that the certification hadn't been included. So if there is a common theme running through these recent judgments, it is, as I mentioned at the beginning of my talk, the move towards procedural rigour and the requirement to make sure that we are not only complying with CPR, but demonstrating that we've done all in our power to do so. Thank you very much. I am going to hand over to Charles now.
Well, thank you very much, Miranda and Fiona, and it's good to see so many of you all here attending today. I'm going to cover 3 topics. The first is standing and academic cases. They're 2 different topics, but they come up in similar situations. The second is about delay and promptness, and the third, I'm just going to briefly cover payments on accounts. I should just apologise at the beginning. I've got either a cold or quite bad hay fever, and so I probably sound a bit different from usual, and also may be a bit sniffly. Sorry about that. So standing in academic cases, going to start with this case, DM and Secretary of State for the Home Department. So claiming there was a child refugee whose family applied for entry clearance to be reunited with him. The claimant brought a claim for judicial review, but at the same time, the family were appealing against their refusal of entry clearance. He was granted permission on his judicial review claim, but the family's appeal against the entry clearance refusal was subsequently allowed, which meant that they were actually able to come, and so there was no substance to the judicial review claim in terms of the decision had been taken. But the claimant's judicial review claim had another limb to it, which was he challenged the ongoing decision or policy decision that parents and siblings of refugee children were not entitled to family reunion on the same basis as spouses and children of adult refugees under the immigration rules. So while his dispute in relation to the actual decision had fallen away, he had a wider point about the policy that had applied to him in the past, but which no longer affected him because his family were granted entry clearance to come to the UK. So the Home Office there disputed the standing that he had to bring that challenge because they said he's not affected by it. He had, in that case, filed medical evidence that the separation from his family, the refusal of entry clearance, and the appeal had a significant detrimental effect on his mental health. And his witness statement itself also said that if the way the Home Office treats cases like mine and my family's is against the law, I want that to be recognised. I would really like to be able to use my experiences to make sure others do not go through the same. The basis on which the defendant contested standing was that, well, there's actually no relief that could benefit him anymore because it's not going to affect him because his family are here. But they also said there would be better placed challengers who could bring the claim. But the court held that he did have standing to bring this claim. They held he was directly affected by the matters complained of. Although his parents and siblings were granted leave, that process was longer, more difficult, and more stressful than it would have been if the immigration rules had been amended in the manner contended for. And that has contributed to his mental health issues. And importantly, they said there was no identifiable alternative claimant who was actually better placed than the claimant. And I think it's important to note the context here. So there had been a previous case on the same issue in which sorry, forgive me, my hay fever is now coming up. There had been a previous case on the same issue in which the court had said, well, this particular claimant doesn't have standing because there are other claimants who are bringing similar challenges who were better placed to bring the case. So this had already sort of come before the court once before, and the judge asked the Home Office counsel in the case, well, is this happening again? Do we have another claimant in the works who could bring this case on another occasion? And so as a result, the issue would be brought by someone who has a better interest to bring the claim. And Home Office counsel in the case could not identify such an individual. So I think that's important, because this issue comes up quite a lot in situations where someone is affected by some wider systemic issue, which they, for one reason or another, no longer become affected by, because either they get granted the particular thing that they're seeking, or their circumstances change, and so they don't need it anymore. But in those situations, often that person feels aggrieved by the process they went through, in which they want to challenge it. And there might be wider players in the field, NGOs, etc., who recognise this as a wide issue, but don't have anyone who could bring the case to kind of get that into court. And what this case establishes is that there can be situations in which, even though you were affected in the past by the decision, and so it's no longer, or the policy, and it's no longer going to affect you now, you might still be sufficiently interested in order to have standing to bring the case. In those situations, that is not an academic case, because you are challenging an ongoing policy that is, and you're challenging the legal basis for it. And so there is still a dispute between what you say and what the defendant says. So turning then onto that academic cases question. So in TT, which Miranda spoke about briefly in the context of anonymity orders, the claimant there challenged various failures under the Children Act, and they alleged that claimant hadn't been treated as an eligible child, or alternatively as a relevant child under the Children Act. They also alleged there was an unlawful policy being operated by Essex County Council. However, before the hearing, the claimant turned 18 and so was no longer a child, so could not be an eligible child or a relevant child. And the local authority said it would treat her exactly as if she had the status of a former relevant child as well. And so local authority said, well, you've got what you wanted, so this is an academic case. But the claimant argued that she hadn't received all the practical relief which she seeks, and she sought a declaration spelling out the past unlawful treatment which she had faced before she turned 18. The court held, in relation to a declaration in general, they said, well, declarations can be made in respect of a past wrong, which has been made good, but there would have to be exceptionally good reasons for the court to exercise its discretion to do so. And simply a wish to have a declaration wouldn't of itself be a special reason why you would be seeking a declaration. There's much wider case law on declaratory judgments generally, which isn't too peculiar to judicial review cases, but also is in private law context. And there, the test that is applied is whether there's a real and present dispute between the parties before the court as to the existence or extent of a legal right between them. And the court said here, well, claimants received all the relief she reasonably could, and so there is no real and present dispute, and so therefore the case was academic. So with the case being academic, the court then referred to the well-known decision in Ex parte Salem, which said that generally academic claims shouldn't be heard unless there is a good reason in the public interest for doing so. And in that case, the court gave as an example when there's a discrete point of statutory construction which arises, which does not involve detailed consideration of facts, and where there might be a large number of other cases, or which might be in the works or about to come into the works. And so the issue would need to be resolved at some point. So why don't you do it here, basically, is the idea. And in this case, in TT, the claim did raise a hitherto unaddressed point of statutory construction, required consideration of a number of Supreme Court cases, and it had been identified that there were at least 75 other children who could be affected by the judgment. So the court said, well, that's a good reason to hear this claim, and so it decided to proceed with it. But in terms of what that means, in terms of what the court can order, Mr. Justice Mostyn held that, in his view, where an academic claim is determined, it's not appropriate for the court to do anything more than to record its findings and decisions in its judgment. plainly no positive, prohibitory or mandatory orders or formal declarations should be made, such orders or declarations would be wholly inconsistent with the claim being academic. I'm not entirely sure that is going to be right in all cases. And I'm sure that if someone did dig around, you probably would find cases where the court found that the case was academic but nonetheless made a declaration. I think it's probably right in relation to prohibitory or mandatory orders. I can't see how that would work in an academic case, but I'm not sure it's obviously right in relation to declarations. So I think that might be something to watch this space. And I don't think there was any, there weren't any cases cited in support of that paragraph. So turning then to delay and promptness. There was a very high-profile JR earlier this year, which was brought by British Gas and other organisations against the transfer of the business of the Bulb Energy company to Octopus Energy, following Bulb's going into administration. And in that case, while the troubles facing Bulb had been in the works for a number of months, the actual decisions in play there were taken on the 27th of October and the 7th of November last year. They weren't published until the 29th of October and 9th of November, respectively. The claim was issued just over a month later on the 28th of November, and it included applications for urgent consideration. And they said they on using Form N463, and British Gas said that they recognised the need to bring those urgent applications on the 24th of November. But the court, in a very long judgment, in which they also considered the merits of the case anyway, because it was a rolled up hearing, refused to grant permission to bring the claims because they said the claims had been hadn't been brought promptly. So just as a reminder of the rules on this, a claim form has to be filed promptly and in any event not later than 3 months. I think everyone knows that the strict time limit in judicial review claims outside the planning and procurement context is not 3 months. It's promptly and not later than 3 months after the grounds to make the claim first arose. And the Senior Courts Act also includes provision that if court considers there has been undue delay in bringing judicial review, then the court may refuse permission if it considers granting the relief sought would be likely to cause substantial hardship to or substantially prejudice the rights of any person or would be detrimental to good administration. Importantly, time runs from the legally operative decision. So there's a planning case there, Burkett, which said time runs from the date of the decision notice and not from the earlier planning committee decision resolving to grant the decision. The date upon which a claimant becomes aware that they may have grounds in law for seeking to challenge a decision is irrelevant to the question of when the grounds to make a claim first arise. However, it may be relevant to the question whether the claim was filed promptly or whether the time should be extended to bring the claim. There is one caveat to that, which is that there is a line of case law that says in certain contexts, notice of a decision is necessary in order for it to be given effect. But that there's sort of particular cases in which that applies. So what were the factors that led to the court deciding in British Gas that that the claim had been hadn't been brought promptly, even though it had been brought within 4 weeks? I imagine a number of people listening to this probably thinking, gosh, 4 weeks, it's really not long at all. That's even less than the planning 6-week time limit. It's just within the procurement time limit, but most cases take quite a lot of time to get off the ground. And so it feels perhaps like a harsh judgment, but the reasons why the court said that it was unduly delayed were that British Gas had applied to join Chancery Division proceedings relating to the underlying matter on the 11th of November. So that was a couple of weeks after the decision was formally announced. And those were adjourned precisely so the claimant could seek further information and consider launching a judicial review, and they had to move very speedily after this. The court said there's a distinction between needing to be aware of the details of the matters which might enable you to support any grounds for judicial review and being aware of the essential substance of the grounds that would be available to you in order to bring a claim. And they said in the context of this case, you didn't need to have all of the details about the matters that could support a ground for judicial review. You just needed to know about the essential substance of the matter, i.e. the kind of headline points why you say it's unlawful. And that's because in this case, there'd been kind of general suggestions that if this decision is going to be taken, it's going to be unlawful for quite some time before the decision was actually announced, and there'd been correspondence about it. The court also said that a claimant doesn't need full disclosure of all the underlying matters in order to bring judicial review proceedings. And the court actually said that normally the grant of permission is the trigger for the duty of candor, and that might be when you might find out further information about the judicial review claim. I think that reasoning feels a little bit uncomfortable in the context of other situations where the court has said that the duty of candor applies even at the pre-action stage. And there was the recent decision in relation to seizure of mobile phones from those arriving on small boats in HM, where the court made very clear that duty of candor does apply at the pre-action stage. I suppose the circumstances around the mobile phones case were particularly unique, and what was happening there was not really a sort of necessarily a failure to disclose a particular document, but rather a kind of giving a completely misleading impression as to what had actually gone on. The court also didn't accept that a reason why the delay had been caused was by the need to write and receive pre-action protocol letters. The court kind of looks at that in a bit more detail and says you don't need pre-action protocol letter in every case. The pre-action protocol makes clear it doesn't apply in urgent cases, for example. And it also says that that's never been a justification for delay or failure to issue outside the 3-month time limit. And so the court concludes that while generally judicial review claims should be commenced with adequate information obtained to justify bringing the claim, that does depend on the context. And here, it was of utmost importance that proceedings were being commenced very speedily. And that's because this was in the field of finance, where case law had already recognised that delay of even a few days can be detrimental to the interests of third parties and good administration. So I do think that this case was particular to the circumstances, and I'm not sure we're going to regularly see cases where someone had failed to bring a judicial review claim in less than 3 months being found to be unduly delayed. Just finally, on costs on payment on account, I mentioned this case not really because it sort of sets any ground precedent, but rather it's just a useful, I think it will be a useful one to point to if you are seeking payment on account of costs, if the defendant has agreed to pay costs, and where you need to wait for detailed assessment. I mean, this is going to be particularly the case in legal aid cases. The claimant there had sought payment on account of 60% of the schedule of costs, but the defendant had asked instead for payment on account basically in a sum that they would determine, and if not, in 40%. And the court went along with what the claimant said and ordered 60% payment on account. And I think just really importantly, what was in favour of the claimant there was that, well, they said it's a legal aid case, so there's going to be a professionally drawn bill of costs, professionally bound to bill only what work had been done. This was a standard order, and 60% of the bill did not risk overpayment and was an amount that the claimant was almost certainly going to collect. But I think really what kind of got it for the claimants was they had a very well drafted witness statement from their solicitor explaining the billing, explaining that they considered it to be accurate and in line with similar cases, and that this order had been made in at least 7 other cases recently in the last 6 months. So that's my quick overview of the last 3 months, and I think we now have time for questions.
Yes, thank you both very much. That was very helpful. Nobody has been moved, so excellent was your presentation, to send us any questions, because you've answered any that they have. I just wanted to raise a couple of points. Firstly, I wanted to talk about this issue of anonymity. I note that you mentioned Mr. Justice Mostyn a number of times, who sits as a family division judge as well as an administrative court judge, and he has been responsible in the family division for lots of work on anonymity, because obviously the family division until recently there was a sort of a default option that everybody was made anonymous for all purposes. And I certainly know his views about anonymity in financial remedy proceedings are not universally shared, and he takes quite a somewhat, I don't know, is liberal the right word? A somewhat more liberal approach to the need to name people than others would. I mean, Miranda, do you think that this is just adding a layer of additional complexity where it shouldn't really be necessary? Because it should be obvious those cases where people should be anonymised and obvious where they shouldn't.
I think it may be. Firstly, you're very right to flag that to date, it has largely been led by Mr. Justice Mostyn. And of course, MNL is written by Warby, but MNL is quite distinct from the kind of cases that I often deal with.
MNL is about somebody who has been accused of serious criminal offending. And the question is whether or not he should have an anonymity from that serious criminal offending. So there are a number of issues which are raised there, aren't there?
Exactly. And you're looking at a balancing exercise where there's legitimate press interest. Whereas if we look, for instance, at my case of AH, you're talking about a family of asylum seekers who are left in what we have said is inadequate accommodation. And if you look at the Court of Appeals guidance, you would think that it should be, if not automatic, there should be perhaps a presumption in favour of that. So I think, firstly, it may be that you'll get different judgments from different judges. I've certainly had much more generous and automatic decisions from most other judges. And secondly, I do think there is a risk of this adding unnecessary procedural hurdles to urgent legally aided cases that already have a huge amount to do pre-issue.
Yes. And certainly from sort of my experience when it's coming to bringing cases, particularly on behalf of children and vulnerable adults, we nearly always automatically consider that whether or not they meet the statutory criteria. So yeah, maybe that needs to be rethought. And Charles, as far as promptness is concerned, you know, I read the British Gas case with some horror in terms of, you know, 10 days wasn't good enough, but isn't, however, that congruent with a very long line of cases, largely to do with regulatory matters or commercial matters, where was the reality of the judicial review is it would have stopped the energy companies merging? Is that in effect what the effect of what they were seeking to do?
I think so. I'll just see if I can pull up the remedy that they were seeking, but I think that context is highly relevant, and I think that feeds probably not just in terms of the implications of the judgment, but also in terms of what could be expected of the parties. If you're, you know, multi-billion-pound company, you have lots of resources to put into funding litigation like this, and have teams of lawyers already there who can help you bring this kind of case, which isn't going to be the case in many other contexts in which judicial review claims are brought. So I think that's an important context, and if this case was being used against me in a different context, that would be one of the points I would point out. Yeah, I think context is really important, and it's possible probably to read too much into that judgment. Okay,
and in particular, I would be concerned if too much was read into the issue of, firstly, the duty of candour not being engaged, and secondly, that you could issue a judicial review before you've really got any idea of what your grounds are. Because, I mean, certainly in a number of cases, judges have been highly critical of those sorts of kitchen sink type JRs. And, you know, it might be this, it might be that, it might be the other. So I think you do risk, if you follow that, of yeah, I mean, my advice would probably be don't do that unless you absolutely have to. But I do understand how in a real emergency you might just need to say, we think it's this. But I mean, in the vast majority of cases, the judge would probably say to you, well, go away and work out what it is before you come and tell me that. Do you both agree with that?
Yes, absolutely. And it's quite interesting. We've got a question in the chat actually about, given the bulb judgment, could we see skeletal grounds being filed and then subsequent reamendment? But I would agree that you want to err on the side of getting your grounds right rather than getting an unusually tough decision on promptness. But I don't know whether you agree, Charlie.
And the questions also asked about procurement. Well, I would say you have to be very careful about that in procurement, because there's been a number of cases. As we all know, the procurement deadline's 35 days. So it's, you know, less than 6 weeks in effect. And there've been a number of cases in which people have sought to bring grounds outside that time, where the courts have said no, and that you can't amend to sort of include matters. So I think you're a bit damned in a procurement case, although in a number of procurement cases, people do tend to bring, shall we say, a greater number of grounds at the beginning of their claim in order to cover off and avoid having to try and amend later on. And I certainly think it would be dangerous to seek to rely on something very skeletal in the hope that you'll be able to amend later in a procurement matter. Anyway.
I think it really depends on the allegation, doesn't it? Because if you're alleging that there's been a failure to take something into consideration, sometimes you don't really know whether or not that's true until you get disclosure of the ministerial submission that was made. So sometimes you almost necessarily are stabbing in the dark, because you don't really know what's there. I think you just have to be cautious how you plead these things and kind of make sure you reserve your position as a claimant, and kind of if it is possible that there is an answer to your claim, maybe say that on in the grounds. And say, you know, this is without prejudice to whatever may be disclosed by.
I mean, there's nothing to stop you saying we think this is the case, but we don't know. Because we haven't seen the documentation. But you know, had they given us the documents promptly, we wouldn't be in this position. I think
what you couldn't really do is say, oh, you know, the ground is that the defendant proceeded on the basis of an unlawful direction from this other defendant, which you actually have no idea whether it's been made, and you've just made up to plead a ground. And you could only ever know if it's disclosed to you. I think things like that.
Yeah, I think it's got to be something which you're pretty certain, you know, it's material that you know was before the decision maker, not we have no idea what's going on here, but who knows, they might have thought about this. Okay. But I think again, I really wish that Parliament, instead of grappling with some other issues, might sensibly grapple with the issue of promptness in this context, because I find it very difficult to advise clients about what is seen as prompt, and it is extremely variable in all sorts of cases. Do you two have any particular views or tips you'd like to give people?
Oh, I mean, be lucky and you're judge, frankly, when it comes to promptness. What I try and do is I try and show my working. So in cases where potentially we might be issuing towards the end of the 3 months, what I will normally do is I will make sure there's a detailed witness statement from my solicitor explaining the exact time frame of their instructions and the actions taken. If my client wasn't able to get legal assistance quickly, we'll be setting that out in their witness statement. Also, I think regular pre-action correspondence, including potentially asking the other side not to take a point on timeliness if you have good reasons, if, for instance, you're waiting for disclosure from them, can be helpful.
Charles, anything else? Any other little handy tips?
I mean, I suppose you just work as quickly as you can. I mean, there are sort of limited situations in which you can kind of provoke another decision, but the case law is very cautious about allowing claims in those situations. So simply asking them to reconsider and then JRing their upholding of the decision on reconsideration is unlikely to lead to a fresh decision that you can JR.
I agree.
You know, I
think in those circumstances, it's better to issue out of time and provide the reasons why you're issuing out of time, because I mean, there is a whole line of case law which does allow you to issue out of time, even if it's not prompt, providing that your case is good enough and there is a good enough reason to do so.
And I also think that one lesson we can take from British Gas is you don't have to be too constrained by the pre-action protocol, because the court kind of made clear that that shouldn't restrict you. And I think that's important when considering what level of timescale to give a defendant to respond. I think that it does need to be reasonable, because if you're going to give them like 2 hours. In most contexts, that's not going to work unless you're in kind of urgent removal cases.
Yeah.
Then then maybe you just shouldn't send it in the first place. But I don't think there's anything wrong with saying, look, we need to give you a very short timescale because we think that if we don't issue before X date, then there will be a promptness issue. So that's why we've given you such a short space of time. And if we don't hear from you, we will just proceed to issue.
And you can always ask. I often in those sorts of cases say, we're happy to agree a stay for you to be able to respond substantively if the issue is going to be timing in terms of promptness rather than interim relief. Seems to me that there are two different issues. If you're running up against a promptness issue, but you know that the other side will want to respond substantively and you think it might settle, you can always say, we're going to issue, but then I'm happy to agree a stay with you of this claim pending your substantive response to a pre-action protocol letter. I mean, sometimes that works, sometimes it doesn't.
The other thing you can also do is agree an extension of time for filing acknowledgement of service, so that they have a bit more time. They had the kind of extra 2 weeks they would have had from the PAC letter. You can also do that.
So the gentleman who has asked us some questions about bulb said again that the claimants were simultaneously arguing in the insolvency court that the relief they were seeking in JR would cause chaos. So I think there was a particular reason why you needed to be particularly prompt in terms of, I don't pretend to know the interrelationship between insolvency proceedings and the judicial review court, but I suspect there were all sorts of issues to do with preserving people's assets. And the reality is ensuring that people continue to have an effective gas supply, which is probably quite important. Well, thank you so much, Charles and Miranda. Thank you to everybody for listening. Thank you for all your questions. I hope you found this helpful. We shall be returning, I think, in July or August even for another update, because we're going to do this on a quarterly basis. And we hope to see you then. Thank you all so much. Bye-bye.
Thank you.
Bye.